Out. All right.
Okay. All right. So we're going to take that as a no. We're going to proceed. We're going to proceed to the growth management overview and the staff report. So Emily, will you start that?
Mm-hmm. Matt, am I reading that or are you?
I can go through this if you'd like.
Okay, yeah.
If you could scroll up, Emily, just so it shows the agenda for a second. So this is the Development Review Board's annual growth management allocation hearing. This hearing happens once a year as called for in Chapter 11 of the Williston Unified Development Bylaw and is an interim step in the residential subdivision review process for any project that will create new dwelling units in the town. So this meeting is a little different than any other development review board meeting that happens during the year. And I just wanted to have the agenda in front of everybody for a moment. So we're at number 2 right now. I'm going to just go over the general overview of growth management. Then the DRB will proceed to number 3, which is to hold an individual hearing for each project, where we'll go over the staff report for that project and the staff's recommended score, discussion with the applicant and public, and then each of those hearings is closed. Following those 3 hearings, the DRB will go to number 4, closed deliberations, to discuss what it wishes to do in terms of assigning scores and allocation schedules. The board will then come out of its closed deliberative session for number 5 to return to its public hearing or public meeting where it can vote on its determination for allocation and also review and approve the March 10th minutes. So with that said, I'll just very briefly go over growth management, and Emily, just kind of scroll with me if you can, and we'll try to keep everybody on the same page. So residential growth management allocation from the DRB is required to construct new dwellings in Williston. The only exception to that requirement is the inherent right to build one dwelling unit on an undeveloped parcel that was created in the town prior to 1990, which was when Williston adopted the growth management system. So this is all in relation to Chapter 11 of the Williston Development Bylaw. What's under review tonight is any project that would add residential units to the town that received pre-application review by the Development Review Board during calendar year 2019. Growth management is a part of the town's development review process. It is intended to meet some objectives that are listed in the bullet points there to ensure that residential growth doesn't exceed the capacity of the town's existing infrastructure, and to support planning for the expansion of municipal facilities and services, to encourage residential subdivisions that successfully implement the goals of the town plan, to support the development of a compact, pedestrian-friendly mixed-use center in the Taft Corners Growth Center, and to reward the protection of open space resources identified in the open space plan and the provision of trails, energy conservation, and other actions residential developers can take to help implement the town plan. As I said before, this is an interim step. These projects have been through pre-application, and should they clear growth management and receive an allocation schedule tonight, they would proceed to the discretionary permit phase of review. So what happens in growth management, applicants receive a survey early in the calendar year after they've gone through their pre-application, and they are asked to identify certain attributes of their projects for which Chapter 11 outlines points that may be scored. We're talking about a 100-point scale in all cases here, and any representations made by applicants about attributes of their projects that gain them points in this process are binding going forward through the discretionary permit, final plans, and eventual development of many of these projects. So there are some commitments that are made by applicants when they sign up for growth management that they have to fulfill if they're going to move forward with their projects. This is the first year under which projects are being reviewed for some revisions to the criteria that were adopted by the select board this time last year. So in this staff report this year, we're calling some of those amendments out. Some of them are related to scoring, and some of them are related more to the way growth management works. So one big change is once projects get an allocation schedule, they are allowed to proceed through that schedule, building any of their units at any time once that schedule has begun. So, you'll see later in the hearing, we'll be talking about units that are assigned a particular start date in a future fiscal year. But as long as a project has at least one active unit that is available in the fiscal year in which they're looking to build, if they build that unit, one big change through their construction schedule. They are not having to wait through that schedule that each unit is assigned. Building any of their units early at any time once that schedule has begun. System. So we also see later in the hearing we'll be talking about units that are assigned a particular start date. Many of the board members sitting tonight will remember a time 8 or 9 years ago we had a lot of expired projects that had to come back in and reapply for allocation. So they build that unit. That is no longer the case. However, if projects go too far out past their allocation schedule, they revert to what's called a slow build provision. And the impact of slow build, if you have a 2-lot split, is nothing at all. But if you were to get a very large project approved through growth management and then not build it for something over a decade, the slow build would limit you to a handful of units a year, and as an applicant, you would likely come back in and reapply to have that project reviewed. So that's the intent of slow build. Deal with the kinds of expirations the town usually has while still ensuring that large projects are reviewed under current version of the bylaw. All of the units that were approved in prior versions of growth management are subject to these new build sequence and expiration provisions. So nobody with active units out there has to worry about expiration the same way they used to. Additionally, projects that have phased allocation can build through their schedules, as I described before. One change that is significant in terms of the review process is the revisions adjusted what the allowances are for exemptions for minor subdivisions. The DRB may recall projects in the past where you could give a project in 1 year 4 exemptions, and you could give them all to one project. This would be for a project that could not meet the minimum score of 30 out of 100 points. That revision now means that exemptions can only be given to projects on a parent parcel of less than 10 acres and only for projects requesting 2 units or fewer. So smaller projects, 2-lot splits, the kinds of things the town plan and bylaw intends for those exemptions to work for, but not for larger projects or projects with larger parent parcels where there's more opportunity to score points toward the minimum score. So the scoring criteria, as I mentioned, were also adjusted. So we had a conserve energy criteria before. We still have a conserve energy criteria, but it's been significantly made stricter. And now keys, instead of keying to the Energy Star standard, we're talking about the Efficiency Vermont high performance level for maximum points with on-site energy generation. So that criterion has gone from being sort of almost everybody got it to something that's actually challenging to achieve. We also have a category in the growth center and in the remainder of the sewer service area called sustainable transportation. This offers points for projects that will build a sustainable transportation facility, which if you look at the description in the criteria, kind of looks like a miniature park and ride, essentially. You provide car share spaces, bicycle lockers, and EV charge, carpool spaces, things like that. So it's a way to enhance people's ability to shift modes of transportation as part of their day. So that's a new one. There are points available for that, not in the ag rural district, but in the other 2 districts of town. So I mentioned before, growth management is a competitive process. It involves a score, and the DRB under Chapter 11 says that the DRB shall award units to proposed subdivisions according to their ranking. So the idea would be that the higher scoring project would get allocation should there be competition between 2 projects for the same pool of allocation. And as I mentioned, folks who cleared pre-application in 2019 received a questionnaire in January and had to answer some questions about the attributes of their project, for which points could be gained under the review system. So tonight, as Scott mentioned, we have 3 projects requesting allocation. DP 1701 Northridge. The Northridge subdivision is looking for 18 units. This is the second half, essentially, of the units that would be needed to build out the entirety of this project. Northridge is a fully approved, fully platted residential subdivision that otherwise, but for the allocation to build these remaining platted lots or planned units, is an approved project. And this sometimes happens with larger projects where they cannot get all of their allocation the first time they go through review. We have 2 projects outside of the sewer service area in the agricultural rural residential zoning district, DP 20-08 McDonnell Gata. This is 1256 Old Stage Road, which is Old Stage Road north of Mountain View Road, looking for 1 unit of allocation for a 2-lot split of a parcel with an existing house. And DP 20-15 Mezuzah 1120 Butternut Road, also in the ag rural zoning district, also a split of a house with 1 dwelling unit on it, seeking 1 unit of allocation to build 1 additional dwelling unit. The next table, table 2, you'll see that the staff has proposed a total score for each project. For the Northridge project, the staff proposed score is 48 points. For McDonnell Gata, it's 20 points. This project, under staff's recommended score, is below the 30-point minimum, but staff notes is eligible for the exemptions under revised Chapter 11, as I described before. And DP 2015 Mezuzah, again seeking 1 unit in the ag rural district with a staff proposed score of 30 points, meeting the minimum score necessary to receive allocation. The next table, table 3, summarizes the staff's proposed allocation schedule for these projects. And you'll see there that this is, later on, there's the big complicated table that shows all of the available units throughout the years and across the town. But in summary, the proposal here is to provide Northridge with 17 units. You see 18 requested up above and 17 here, and I'll go into the difference in the staff report. The intent is to provide Northridge with the remainder of the units it needs to build, and I'll talk about that. And you can see that the proposal would be 11 units in fiscal year 2021, the year starting on July 1st, 2020, and then 4 units in 24 and 2 units in 25. Again, remembering that under revised Chapter 11, the developer does not actually have to wait for those 2024 and 2025 units. They don't have to wait for those years to start if they're already into their construction schedule. And the last table remains to be filled out by the board. That's the business of the board tonight after it reviews these projects to adopt an allocation schedule based on the scoring that it establishes for these projects. We have 3 proposed motions. This is the way we've done it in the past, is to do a motion for each of the geographic areas of town. The first motion is really a non-motion. It would be for the growth center if we had any projects there. The second is for a project in the other sewer service area, this year Northridge. And the final motion is for our 2 projects that are outside of the sewer service area.
Thank you, Matt. So that's the staff. So that's the individual overview. Individual overview, I guess. So we're going to come up on the individual staff reports. Let's make sure we got them here. Bear with me 1 second. All right, here we go. So first up, we're going to start with DP 17-01, and we're going to open up Northridge, DP 17-01 at 719. Do we have the applicants here? Matt or Emily? I can't hear you.
Yep, I am promoting Ben Avery to panelist.
Okay, great. Matt, all right. I can see Matt talking, but I can't hear him. So you must have your mic on and his mic off.
Matt, I have your mic on.
It's back on as long as you can hear me.
I can hear you.
Now.
Okay, I can hear you now.
Can anybody see or hear me?
Yep.
Okay.
So hang on one second. Let's see here. Ben Avery, there you are. Look at that. Okay.
Good times.
There he is.
Please state your name and address for the record.
Benjamin Avery with BlackRock Construction, South Burlington, Vermont.
Well, welcome, Ben. So we're gonna let staff go first. I do have a question before you go. Emily or Matt, which one of you is reading this?
I'll read through it, Scott.
Okay. So, Matt, did the scoring change? Did the proposed score change from the first time this was approved through growth management to the second time?
Yes, it did.
Okay. All right. So you'll review the changes?
Yeah, I mean, I'll sort of get into it and we can talk about any of the individual scores, but most of it is related to the changes to the criteria that have occurred between when the project was first proposed and this time.
Okay, that's kind of what I was getting to. So, all right, staff goes first. Matt, you're up.
Okay, so we have a request for DP 1701 Northridge Subdivision Phase 2. The request that was made is for 18 units of allocation. And I'm seeing a request for the document to be zoomed in if possible. There we go. You can see in the summary table the staff proposed score in each of the criteria, and then I'll just work down through those. But first I want to go down past that table and just discuss the difference in requested 18 units and recommended 17 and make sure that we, the board, and the applicant are all on the same page with that.
Okay.
So I don't know, Emily, if you could scroll down to the staff comment there. So the discretionary permit for the Northridge subdivision, which is for the total development, is an approval for 39 dwelling units. The parent parcel had no houses on it, so staff's recommendation was there's an inherent right on that parcel to build one unit. 38 units would be the total required allocation. In 2017, the project received 21 units, so it appeared to staff that 17 were the number of units needed to achieve the full build out of the project. So I'd like to pause there if the board or the applicant want to sort of make sure that everybody understands the number of units requested.
And do you agree with that?
Yes. So I did have some discussions today with Emily. I was confused by the 17 versus 18, and she did explain to me the inherent right that comes with each sort of master lot. So I understand and agree.
Okay, great.
Great, thank you. So what you see summarized underneath the staff comments with that calculation is the total recommended allocation schedule. And noting that this project does include an affordable component, but that was all allocated in the first phase. So what we're talking about tonight are 17 market rate units, and again, 11 starting in fiscal 2021, 4 in 2024, and 2 in 2025. We do have two board members, Pete Kelly and David Saladino, who recused themselves from the review of the Northridge project originally because they are residents of Southridge. And we can
Okay.
continue from there.
What would you like me to pull up?
Just head for the next page.
It's just one page. I could pull up the questionnaire.
Yeah, pull up the questionnaire.
Let's go through the project overview. There you go.
Yep. So this is the questionnaire that is submitted by the applicant. Actually, Emily, if you can just land on that top bit for a second, you see
Matt, can I interrupt? Sorry, I timed my interruption earlier, but I realized it was on mute, so I was talking to myself. Just a really quick question under the on the previous page where it talks about affordable. It had noted 17 market rate homes that are being requested, but in the packet, it looks like it indicates 9 affordable housing units. Maybe we'll get to that when we get to that sheet.
The 9 affordable units were allocated in the first phase, as I understand it.
So, hey, Matt, and David. David, are you still recused?
I no longer live there, but I've got a connection there, so there's an appearance of a conflict.
Okay. Okay. So you no longer live there? I don't. No. My ex-wife does though. Okay. Well, we don't need to get into that. That could be information for the deep state. Yeah. Okay, fine. So you're no longer recused. Pete Kelly is still recused. I think I should stay recused. I think it's just unless we need it for a quorum. I think just to be safe. All right. So that's I guess that's what I'm trying to get to. If you are still recused, then you probably shouldn't be asking questions. All right. I duly noted. I will refrain from asking questions.
I'm still recused, Scott.
Okay. Thanks, Pete. Matt, back to you.
All right, and Pete, to confirm the ongoing reason for your recusal is that you are a resident of Southridge.
Correct.
Thank you. That's just the statutory requirement is that you recuse and state why. So I wanted to just land really quickly on the top of this page. You note all of the numbers in bold that begin with 11. Those are the scoring criteria as revised by the select board last year and the amount of points available in each of them. So just to summarize, 11.8.1 through 11.8.9 add up to a total of 100 points. And we can just take a look at the project through those criteria. So Emily, if you want to scroll down through the survey. So the first criteria is energy efficiency. This would have been a criteria that the project would have scored points in prior years because we were using the Energy Star standard. This criteria was revised by the select board. And now, as you note in the survey there, you have to identify any units you're going to build at the Efficiency Vermont high performance level and whether there will be any on-site energy generation. And the applicant has answered no, there will not be any units constructed at the high performance level. And there is no on-site renewable energy generation. So the score there would be 0 points. You can go on to the next one if you like, Emily. So within affordable housing, the project is proposing to build 9 units between 80 and 100%, or rather 9 units that will be affordable at a level between 80 and 100% of the median income level. This is the median income for Chittenden County. And so these 9 units, as I mentioned, were allocated in a prior phase of the project. The practice of the board and the direction in the bylaw is that when a project is broken into phases, you do review the project for any future scoring. You review it against the entirety of the project, not just the phase that's under discussion in the allocation hearing. So even though those units were promised in the first phase, the project still scores points for having those units as part of its project. We'll go down to offering housing choice. This is a criteria that is related to the diversity of housing types within a project. So the town plan encourages new residential development to include a diversity of types of housing. And in this case, the applicant has identified, as you see in the numbers in the right-hand column in the responses, a number of different types of dwelling units that will be constructed. So you have some single-family dwellings, some multifamily dwellings, and of those single-family dwellings, some of them are on an individual parcel of land, some of them are on common land, and I think there's no more responses lower down, Emily, if you want to scroll. No. And the applicant has noted in the narrative, none of the stock designs contain an accessory dwelling unit, but a number of the units are capable of having one included. There's a range of lot sizes from 0.3 to 0.8 acres. Finished floor area of units proposed in this project range from 1,500 to over 3,000 square feet. And price ranges are anticipated to be anywhere from the low to mid 300s up to $600,000 for the largest homes. So the next criterion is to provide neighborhood space, and the applicant's narrative identifies a number of outdoor features that were designed into the project. There's a public portion of the Williston bike path, as well as a floating primitive trail easement across some of the property. And then there is a community pool and pool house with an adjacent playground provided as neighborhood space for homeowners. And the applicants also noted over a mile of public sidewalks within the project. So those are all elements of neighborhood space as discussed in the town plan and 11.84 of the bylaw. Paths and trails, the applicant is identifying that all of the units in the project will be served by the path and trail system, that there are over 2,500 feet or approximately 2,500 feet of on-site path and trail segments proposed, including easements, and that there's approximately 500 feet of new path, this is multi-use path or bike path, that will be constructed as part of the project. 11.8.6, design for context. This has been one of the traditionally a little bit more challenging criteria to assess. But the idea is that subdivision should provide for a scale of housing in terms of height and bulk of buildings that's compatible with surrounding uses. It does not mean that what gets built in a project needs to be identical to what's nearby, or very similar even, but it means that the overall character of the residential subdivision will complement neighboring uses. So, you know, the applicants noted that their project is residential, bounded on two sides by other residential subdivisions. Building close to services, this is a really sort of simple quantitative judge. Projects receive points here if they are within certain distances of a focal point, and focal points are mapped spots that are part of the town plan. Town hall and the library are examples, or community green, park, open space. And the applicant has identified that on that map, the nearest focal point is the Allenbrook School Complex, and they are about 2,500 feet via the town path system to the Allenbrook School Complex. Neighborhood design, this is about the layout of the neighborhood in terms of the way the neighborhood utilizes its open space to buffer and integrate the neighborhood, and the management of stormwater and other things that happen besides essentially houses and streets in the neighborhood. So the applicant is noting their use of sidewalks and recreation paths, 22 acres of permanently protected open space that was part of the parent parcel, accessible to residents and the public via trail easement. Also that the open space was laid out in a way that it protects some wetlands and breaks up the settlement pattern within the neighborhood. And this is the new criteria, sustainable transportation. This is not proposed as part of this project, but if the board wants to take a glance at the second paragraph under 11.8.9 there, right at the top of your page, actually if you bump it, there you go. And this discusses what a sustainable transportation facility would look like. So again, we're talking about carpool or transit shelter, carpool parking space, electric vehicle charging port and space, car share space, 2 covered bicycle storage lockers, per 25 dwelling unit equivalents in the project. So for a new project that's planning for how it might lay out, this kind of small public facility that enhances transportation choice might be a way to score points. This criterion did not exist when this project was designed, and therefore the applicant's not proposing to have that as part of their project.
Great, thank you. Mr. Avery,
Yes.
have you read the staff report prior to Matt going through it?
Yes.
Anything that you would like to add to his synopsis?
No.
Okay, all right. Based on the current scoring, do you agree with the current scoring?
Yes, the only thing that I would note for the record is this is this. While I understand the process and procedure exists for the multi-step, this is one of the obvious hiccups in the practice of creating phasing in the allocation process, because the way that planning and zoning works is we wind up with with an approved recorded project, and because sort of the rules change midstream, I don't believe that the town is setting an expectation that we should go back and re-permit our project. Therefore,
I think I'm going to interrupt you and say that I think Matt was pretty clear about that when he started with his preamble about this being an approved platted project.
Agreed. I'm just reiterating it. So is what it is.
Yep. Okay. All right. Your point is noted. Anything else?
Nope.
Okay. I'd like to open this up to our board. Emily, if you can help me with managing the questions from the board.
Mm-hmm.
Do we have any questions from the board members for the applicant?
Jill, you are muted right now. I'm pressing unmute.
Who's muted? Me?
Jill. But everyone else is should be okay. There you go. So everyone should be able to speak.
Jill, do you have a question for the applicant?
Well, I was just reviewing this affordable housing restrictive covenant. What do you know which of the 9 units are going to be subject to this, or is that?
They will be mixed between some of the attached housing and some of the single-family carriage housing located on Zoe Drive on the plan.
Okay, but they are designated. It's not going to be a moving target.
Actually, we are not. We're letting folks choose their lot. So there isn't a unit 1 is affordable, unit 2 is not, unit 3 is. We'll sort of as we move through sales, we will let folks choose on the single family units where they want to be.
Okay, and so if it is an affordable unit, then you'll just make it subject to this covenant.
That's correct. The covenant is a deed restriction, and we've submitted a draft to the town, which has been reviewed with the town attorney. We met with staff last week, I believe, or 10 days ago maybe, to go over some final tweaks. I'd actually have to refer to Matt. I'm not sure that our legal got that over to you, but if they didn't, they will for final review and acceptance by the town attorney.
So Matt, I'd like to chime in and ask, how are you going to track the initial choice, if it's not designated right now, how are you going to track the affordable housing designation for the whatever lot is chosen for it? And I guess I'm not being very clear, I don't think. And I would kick this also back to Ben. Ben, I'm assuming you have prices assigned to each lot, how are you going to determine what is affordable and what is not? So that two-part question, one for Matt and one for Ben. Let's let Matt go first.
Sure. So there are two regulatory responsibilities or regulatory actions for the town here, and for me as zoning administrator. One is to keep track of the overall build out of the project to ensure that there are these affordable units included within it. So if we have 39 units and 9 are affordable, if for some reason I found I had issued 30 permits for market rate units, I know that I can't issue the next 9 unless I'm seeing these covenants taken care of as part of the permitting process. So I will have to maintain an accounting of market and affordable units that are proposed and permitted throughout the track of the project. So that's sort of the.
So let me just add one thing to that, or add into that if you get 30 applications in front of you for market rate, and based on my reading of the Ben's responses to the questionnaire, some of these things will be $600,000, up to $600,000, and I'm assuming they're on probably the larger lots. What if you end up with 6 larger lots with no and you haven't fulfilled your affordable housing requirement? Ben's going to be pretty damn upset with himself.
If I can chime in, obviously we would not do that to ourselves. And if it's helpful, what we are happy to accept as a condition, if growth management can issue conditions, is we're happy to flag the affordable units when we pull the zoning permit. And I think that would be helpful for staff, because then as they track it towards completion and CO, they know that we as the association will be submitting the worksheet and associated documentation prior to closing.
Does that make sense to you, Matt?
It does. That's fine. And to your question, what if any project went and built all of its market units, none of its affordables, and then found that it didn't want to or could not build those affordable units? It's not something that has happened yet. It's certainly something that could happen with some projects someday. And the best answer I can give you is the project would be surrendering its allocation and would have to return to the DRB for a new allocation schedule at minimum to build those remaining units and to be scored under whatever criteria existed at that time. So,
or simply move forward and with the affordable the affordable component on that lot.
Correct. So that's part one of my answer, which is what do you have to do in terms of permitting on behalf of the town to ensure that the promise of affordable housing is met. The second part of the question is, what about as these units, once they're built and they're bought and sold over the years? And the intent of the covenant, if you've seen it, is for that to be relatively automatic and self-enforcing. So literally the income calculation, the price calculation is built right into the covenant. Any title attorney who found this covenant when dealing with a sale would find this document and would find the calculation method that would arrive at a maximum allowed price for the unit built right in. And I should emphasize that in Williston's system, what we're incentivizing is only the price at which the unit is offered. We are not in the business of determining the income qualifications of the person who buys the unit. It is simply the creation of a unit that comes on the market at a price point that is definitionally affordable. And that, for some folks, they might say, well, then the town's only doing half the job. I would argue that what we're doing in regards to that is we're doing the part that we can. Managing the price of the unit is a lot easier than putting the zoning administrator in the position of talking about income qualifications.
Okay.
So this is about unit price.
Got it. Okay. Ben, we're in agreement here?
Yes.
Jill, you did that answer your question?
I wanted to ask, and I think that's what Dave was trying to ask earlier, is were these 9 affordable units given any kind of score in the earlier meeting or the earlier growth management?
Yes, the project, the overall 39 unit project, received a score in the review of its first phase allocation request. It received a score that was in part based on the provision of these units. So this is sort of what I was talking about in answer to David's question. What the bylaw says and what the DRB has traditionally done is reviewed multi-phase allocation requests against the attributes of the entire project. So if there's an affordable component to a project, the project and any of its phases receive points because there's an affordable component to the project, even if the affordable units are not in the phase that's under review at that time.
So would it have been given a higher score if it hadn't? So if 9 out of 38 units would typically score more than a 4?
I could probably tell you what it scored last time, although I don't know that I can pull that record up without losing my screen.
I'm pulling that up,
okay.
But I believe it's also scored 4 points last time. I'm trying
They're the same 9 units.
Yeah.
Oops, wrong year. So this is its growth management checklist from 2017, March 2017, when it went through growth management. It scored 41.5 points.
And 4 points for affordable.
Yes, 4 points for affordable.
Okay, I think that covers my questions.
Okay, great. Any further questions from the board for Ben Avery?
No, I don't.
Oh, sorry. I do have one other question.
Yeah, go ahead.
And this may be, for the design for context, I understand that it's residential, so it achieved all of the 5 points that it could have. But is there a distinction to be made between the type of residential, like the multifamily versus single family? That typically.
Well, here's where zoning regs and this, in my opinion, are in conflict, because you're asking for diversity in housing type, and I'm sitting next to 2 one is a 1990s Vermont subdivision. These are 2 subdivisions that were essentially constructed with, you have 200 homes and about 6 different home designs. So it is as, sort of standard suburban as it gets. And so I understand the zoning directive to create neighborhoods that have a diversity in housing, which is what we've created. But I think you can see the conflict there of then how do you score me? You're telling me to look different than the neighborhood next to me, but then I can get docked on scoring for not looking like the neighborhood next to me. You see what I mean?
So, Emily, if you can scroll to that page of the questionnaire.
Yes.
The top discussion is a quote from the bylaw that it attempts to address that. And so I'm looking at the second sentence. This does not mean that the density or mix of housing forms must be identical or very similar. It means that the overall character of the proposed residential subdivision will complement the neighboring uses. And this is typically one where unless I think in almost every case that I've seen the DRB review this criterion, they've assigned full points to a project. Sometimes when I talk to applicants about what it might mean to design for context, I describe this as points that should something just really, really poorly aligned with neighboring neighborhoods or really just, I don't know how to say it better, bizarrely out of context with surrounding neighborhoods.
Let me chime in and just say that I think we all kind of understand what the Vermont vernacular is. And everybody's got a different opinion on it, which makes it really hard to quantify. But it also comes down to, you know it when you see it. So everybody can make a decision, you know, when we discuss this later on, everybody can make a decision as to whether, you know, they either recognize this or they don't recognize this as something that they have maybe seen before in the area, or whether it's all brand new. So I think that's a fair way of summing it up.
Yes.
And can I just, the sheet that was attached with this, it shows like a carriage house, two, I guess, single family home options, and then it looks like maybe like a multi-unit building. 4 pictures on one page that looks like this. Are those the proposed housing types, Ben?
Yeah, those are likeness only, but yes. Those are likenesses of other homes that we've constructed in the area, and we envision building similar type housing in this development.
Okay. Thank you.
Which we think is consistent with the, or should I say, we feel like the single family options are very consistent with the surrounding area. And we feel like the multifamily and carriage options, which are a different housing type, however, are architecturally in the same vein.
All right, okay, thank you. Other questions from the board?
I'm sorry, just one more from me on the housing type. Will they be, the carriage house is shown as a single story. Is that consistent with what you'll be building there?
Yes, because all of the carriage houses, according to the approval through an agreement with the neighbors, are single story.
Okay.
Okay. Additional questions from the board? Everybody okay if we move on to the audience?
Yes.
Okay. Matt and Emily, can you open it up to the audience, please?
Yes. Laurie Marino is raising her hand. I am promoting her up to panelist, so she'll be able to broadcast her video.
Okay.
And she did submit some additional materials emailed to me just before the meeting. I am opening those up. Laurie, if you want to tell me to scroll around to certain things, just let me know.
I just had a quick question, more in regard to something that you were just talking about, and I appreciate, Matt, your attention to the detail of affordable housing. I'm a little confused that you were saying it was not based on income, where the scoring sheet on that document, the affordable housing restrictive covenant document, seemed to be based on income as the basis of scoring. And then a 2-part question. My second question is what is affordable housing currently in Vermont, where the price point that I see on the sign for Northridge is $329.9, I want to say, and I may have that wrong, so correct me if I'm wrong.
I can address that. The first part of the question was related to, we don't have an income qualification standard for the buyer. In other words, the town does not look at the potential buyer of a unit and have them tell us how much money they make. However, the way that the affordable price level that the unit has to be offered at, or can be offered at no more than, is that number is established based on the median family income for Chittenden County. So when the calculation is made that the covenant calls for, you have to go and look up what the current median family income is for the county. And then if you're, for example, providing a unit that can't be, that has to be affordable for someone making no more than the median, you take that median number, you divide it by 12 for 12 months out of the year, and then you take 30% of that. And so what we're saying is the price can not exceed something that somebody making that median income could pay using no more than 30% of their income. And in the case of a for sale house, we're talking about mortgage, tax, and insurance. So you have to figure out what the current median family income is. You have to figure out what 30% of that is. And then you have to take it through a prospective, mortgage, tax, and insurance calculation that suggests that somebody could actually purchase that unit while making a monthly payment that did not exceed 30% of the current median family income.
So Matt, let me also chime in and say that Laurie, the data is produced by the Department of Housing and Urban Development. This is not something that the town of Williston is involved with. We have no say over this whatsoever. What the applicant is simply agreeing to do based on the approval process is abide by those the figures developed by HUD. They are updated on an annual basis, and it will be up to Matt as the town regulator to make sure that the sale price of the house or condominium does not exceed the amount dictated by HUD.
So is that what that covenant is regarding then? And I'm sorry if I'm just catching up, 329 in alignment with that formula, and is it,
I think it's in alignment with the formula, given that the data, there's only one source for the data, so it's not really up for discussion or negotiation on the part of the applicant. You go to HUD, you pull up the page, you scroll down, you find the part that says Chittenden County, and 80 to 100% of area median, and you kind of run your finger across till you find out what that number is, and that's where you end up.
Right. Okay. So I guess I was just wondering if that 329.9 starting price point that they're advertising, is that in alignment with that? The current number?
To be honest with you, it really doesn't matter.
Okay.
They can advertise anything they want.
Right.
But Matt, it's up to Matt to determine whether that number that they want to sell this thing for is equal to or less than what HUD says it can be.
Okay.
So they can advertise it for $1 million, but when it shows up on Matt's desk, he's going to have to sit and say, guys, it's 329 or it's 319 or it's 317,500 or whatever the number is. I don't know. But we, there is a formula. It is readily available, and it is actually relatively easy to figure out.
Yes. Okay. No, and I've seen the formula on the website, and I'm just was wondering about that price point and the alignment of that. And so thank you for acknowledging my question. I guess since we're here on this part of the discussion, I had submitted the question, is the town receiving the excess of the money beyond the affordable housing revenue being paid to Northridge? But what you're telling me is that the price point just gets adjusted, and so no one gets any excess. It just is a differentiation in
That's correct. There is no sharing. There are other models where it is sharing. I think Burlington has used some models like that, but what the town of Williston does not.
Okay. And then my other question in regard to that was, right, and so you just spoke to that as well. And is this a standard, most towns I'm hearing do, I guess, oversee that process, and that's a good thing.
This is overseen. So it is overseen by the town zoning officer, and it is, and Matt alluded to this or talked about this, it is deed restricted. So there's a trigger in the deed when an attorney is doing a title search to sell or purchase the property, that the attorney must figure this out. They cannot proceed with the sale unless they get a sign off. They can't provide clear title,
Right.
unless they deal with this issue that will follow the property along for the life, for as long as it's in existence.
Okay. Yeah, I guess my concern was affordable kind of thing, and it sounds like there's
Well,
a solid.
your affordable and my affordable and other board members' affordable may very well be different.
Right.
But that's why there's one source for the government to go, to provide what they consider to be affordable.
Got it.
And it does vary by region, it varies by county, it varies by geographic area.
Okay. Thank you.
Sure. So you have, Emily's got your questions up on the screen. Do you want to explain your question about why is the town of Williston so involved? What are you asking?
No, I was just wondering, it was relevant to that particular issue. I didn't, I'd never seen that covenant.
Okay. All right, I get it.
Yeah.
Yeah.
So you spoke to that.
Yeah, Laurie, let me know if you want me to scroll through your letter or go to any other document.
Okay, I can just run through. I mean, some of the questions are totally not where we are at, but I can throw it out there right now just to get it over with. A question about the Josh Diamond exchange of properties. It never really was clear around that. It was public record. So it's out there as far as information.
Okay, Laurie, you're breaking up a little bit.
Involvement of Josh Diamond and the exchange of properties. I was looking for clarification around that, and before any more properties get built on this development, I'm just wondering why that exchange was necessary, and it was public record, and so it was out there already, the information.
Sure, I can speak to that in a general way if you like.
So Matt, I would like to chime in before you start
Sure.
and say that. So I'm reading through Laurie's letter. The areas which we should be discussing should apply only to growth management. We should not be rehashing. This is not a hearing about the efficacy of the project. This is growth. It is based on growth management only. To the best of my knowledge, some of these issues have been dealt with previously through the courts of law, and will not be relitigated here. So with that in mind, let's cover the areas in her letter that deal with growth management.
Okay, so the reason I was, I guess, bringing up some of these issues is because I was told that when the second half of the project was permitted, that I could speak to them further where I didn't have party status to certain aspects in the land use permit appeal. I'm not going to go there, but there are relevant issues such as the displacement of wildlife and the neglect for the permitting stipulations before the project gets bigger. My concern was, there was blatant disregard, and I believe even the town sat down with Rock, and I know it was discussed in court and by the Agency of Transportation about signs being installed before the large trucks enter the development. That was a concern. of mine and residents in the neighborhood, and that the signs weren't even put in place before construction began, before the breaking of ground.
So Laurie, let me interrupt you for a second and say that if I do not have the enforcement action in front of me, the town zoning officer is responsible for compliance with any agreements amongst the neighbors. And if there is an enforcement issue,
But that's a state.
I'm sorry.
That's not a neighborhood agreement. That's state specified.
Okay, I only got about half of that.
Yeah,
Scott,
Laura, you're breaking up a little bit.
there are conditions that are part of the building of this project that are related to its Act 250 permit, including traffic plan and signage and things like that.
Understood, and my point is that while Laurie is free to bring them up, I do need to maintain that, or I do maintain that is not part of the growth management process.
Okay, I was thinking that it might be just because as the project grows bigger, the ability for the developer to manage their proper alignment with state law and land use permit stipulations is a concern. And in this instance, it's a safety concern. You can read what I wrote. I'm not trying to cause a ripple in your meeting.
No,
I'm,
you're
aware of the fact that it was already permitted, and I've already gone through the process. But I guess just moving forward, the points that I'm making, I feel are relevant before more growth continues.
Understood. So you touched on in your first point, you touched on actually kind of two different areas. One of which was some of the land use laws that sounded like is part of Act 250. That would be Act 250. That would not be the Development Review Board or the town of Williston. If anything that was a local agreement on either trucks or stop signs or any items that the town would have jurisdiction over, then that would be something that Matt would look at.
Right. That's not a local agreement. That's state and federal law. And running stop signs, there were 6 tractor trailers that ran stop signs. So I'm just saying there's a safety concern by them not, and I know they're not driving the tractor trailers. The developer isn't, but certainly they're responsible. And I feel like the town needs to know that these things are going on, that the erosion control stipulation wasn't put in place. And that does affect neighborhood design in relation to stormwater. There is a stormwater issue with runoff. So the concern being that, if they're not aligning with these permitting parameters that were put in place to protect, the design, stormwater mitigations, then there might be ramifications down the road. And certainly the traffic issue and the growth, I think, is relevant, because as you get more construction and building on this property, there's going to be more construction traffic. So it's just, I feel, a valid concern and one that's okay to bring up outside of the Act 50 permitting.
So I don't disagree with you. I don't disagree with parts of that. I would state that two comments. Mr. Avery, would you please make sure that your contractors aren't running signs, that the signage is all in the, hold on one second, the signage is in the correct areas. And then Matt, I think it sounds like it would be worth your time to take a look and just make sure that everything within your jurisdiction is correct and as it should be.
No problem.
It's there now because I brought attention to it and I reported it to the state, and then the state kind of visited, and Matt was aware of it too. But the signs are there. The hours of operation were an issue as well for a while. I had recordings of 7:30 in the morning, high decibel levels, and that was part of the permitting also. Matt's been good answering two things, and thank you, Matt, for your attention. It's a consideration before moving forward with more growth on this property.
Okay.
Scott, this is John. I have a question. I'm confused as to which of the criteria that we're awarding points on tonight that this even applies to.
I'm not sure. That was my earlier point, John, and that is that I'm not sure that, I think we're kind of off in the weeds at the moment.
Oh.
I think we're deep in the woods.
Yeah.
I'm sorry, John. So neighborhood, I guess, was the stormwater issue, and I'll leave it at that.
Okay, thank you. Thank you, Laurie, for your comments.
Yeah.
Emily, do we have other questions from the audience?
No one else is raising your hand. If you're on your computer or smartphone, you should have a raise hand button on your control panel. Everyone else, I believe, here is for another hearing or just the public computer next door.
Yeah, I'm alone in the normal DRB meeting room along with the public computer, and I'm the only one here.
Okay. All right. Okay. So does the John, I do agree. We got a little off, but that's okay. There's a public hearing, and people have rights to ask questions as long as we don't get too far off. Do we have any other questions from the board for the applicant? Is everybody's mic turned on, Emily?
Yeah.
I am unmuting a couple folks. They might have to accept. Yep, everyone's unmuted.
Everybody's unmuted. So do we have any other questions from the board for the applicant?
No.
No.
Okay. Does the applicant have any questions for the board?
No.
Okay. Ben Avery, thank you for tuning in tonight to DRB TV. We are going to close DP 17-01 at 8:11.
Scott,
Thank you very much.
I had a pop-up that said Laurie Marino had her hand raised. Was that just a relic from before? Emily, can you tell?
It might have been.
Okay. I don't see her in attendance anymore, so I just wanted to make sure we were double checking that everybody spoke as much as they wanted to.
Yeah, I'm bumping her up to panels just to make sure. She might have stepped away. I don't know. But no one else is raising their hand. It might have been a relic from before. She might have hit it and then taken it down. Yeah.
Okay. Let's move on. Okay, so next up is DP 20-08 McDonnell Gata 1256 Old Stage Road in the ARZD. We're going to open the hearing at 8:13. Emily, you still have Laurie Marino's comments up on the screen?
All right. Deb and Bob should be joining in.
So is it on my?
Promote to panelist. Yeah, let me pull that. I'm just trying to make sure I get Deb and Bob in first.
Yeah, okay. Take your time.
Asking them to start video. Hi, Deb. Hi, Bob.
Hey, Emily, can you hear us okay?
Your volume's a little bit low.
Let me try turning it up. Okay, how is this?
We can hear you.
Can you hear me all right? It's okay? I can make it.
Yeah, I can't. Deb, I can't hear you. Can you turn up your volume?
I've got all
Well, it's not your speaker that you're hearing, Deb. It would be your microphone.
Since we have not had a problem previously, I'm not sure how to turn up my microphone, to be honest with you.
Pete Kelly, you're the computer expert.
Boy, if I'm considered the computer expert, we are in trouble.
There should be
Try your F3 button, perhaps.
Okay, F3, yeah, that's my regular volume.
that worked. You did it.
Hey, Andrea.
Hello.
And Andrea's in too. I hear her, but I don't see her.
Okay, so your volume, I can hear you better. You are coming through a little fuzzy, so I may ask you to repeat yourself. Okay. The Emily and Matt.
Mm-hmm.
Which one? Which of you is actually? Let's get the applicant to give their name and their address, please.
And Robert Bennett, 1256 Old Stage Road.
Okay. All right.
And Scott, I am here, Andrea Dotolo, Trudell Consulting Engineers, 478 Blair Park.
Great. Thank you, Andrea.
Yep.
Okay. So I'll read through while Emily scrolls once again. This, as I said in the summary, is a request for 1 unit of allocation to create 1 dwelling unit with 2 or more bedrooms at 1256 Old Stage Road. The subject property is 9.78 acres in size and has 1 existing dwelling, hence the request for 1 more. At the beginning of the staff report here, you can see a listing of the outside sewer service area criteria in 11.9.1 through 11.9. I'm not quite sure where it goes down to, 0.6.
Hey, Matt. Are you? Hang on a second. Hold on. I got to make sure I'm on the right. I'm on the wrong one. Okay, hang on. Pardon me, everybody. I am looking at the wrong. Okay. All right. DP 20-08. I'm sorry. McDonnell. Okay. Start up again. I got it.
All right. So we're looking at 1 unit of allocation requested to build 1 dwelling unit at 1256 Old Stage Road on a 9.78 acre parcel that already has 1 existing dwelling. In the project score table with the staff's proposed score, you can see the criteria for projects outside of the sewer service area. And you can know just in summary that there are 2 areas in which the staff is recommending points, the design for context criterion and minimize visual impact. You will note also that those 2 do not total to 30 or more points. Thus, the staff proposed score would not meet the minimum score. However, staff notes that this project is eligible for the exemption for minor subdivisions. I'll discuss that a little bit later. Let's just go briefly down over into the questionnaire and look at those criteria. Okay. So as I mentioned, we're in the area of town outside the sewer service area. So the criteria here in the bylaw are different from the criteria that we were just looking at for the Northridge project, which is in the sewer service area. That said, some of them are very much the same, including the energy efficiency criteria as shown in 11.9.1 here. The applicant is not proposing that the new unit be built to the Efficiency Vermont high performance level and is not proposing on-site energy production. Therefore, no points are proposed to be awarded in this category. We'll move on to 11.9.2. I actually back up just a little bit. I should note that even in some of these where the applicant is not proposing to supply something that would score points in the criteria, they are providing in their narrative an explanation of why. And so in this case, the applicants are not proposing to meet the energy efficiency or energy production standard because they are concerned that placing that restriction on a prospective buyer of the property would create an undue burden, and that it throws a whole lot of unknowns into the construction process, and would impose a potential cost on any buyer of this property to comply. And, you know, we have a 2-lot subdivision, so unlike a larger project where there might be some opportunity to spread the costs of energy efficiency and energy production across a lot of units, we don't have that. And the applicant has also provided an attached narrative we can go over at the end that explains a little more about their process as they looked at ways they might or might not be able to fulfill some of these criteria. Now we can move to 11.9.2. Thanks. Okay, so affordable housing. The applicant is not proposing to restrict the 1 unit to be created at an affordable level. And again, you know, in a small project, promising that one unit out of 2 would be affordable presents a significant challenge. I think there might be a little bit of a discussion in the narrative there, just again stating what I sort of summarized there. I don't think we've ever had a 2-lot split successfully proposed to build affordable housing as part of its project. 11.9.3, build paths and trails. So where this property is located in town, it's not located anywhere in the vicinity of any existing or planned town path or trail segments. And that's really what this criteria is about, is if the applicant has the opportunity to provide a trail easement or path construction to the town, are they proposing to do it or not? When the opportunity is not there and the segment can't be built, there's no ability to score points in this criteria.
Right. We talked about this at length during pre-app.
Yes.
Yes, we did.
Within design for context, the applicant is proposing a subdivision lot very similar in size and the same kind of use as other existing properties off Old Stage Road. The project proposes that the new dwelling unit be relatively close to the road right-of-way to maintain the pattern of houses along the roadway on this part of Old Stage Road, and leave the open space and scenic views to the east behind. So if you could envision, you know, looking east from this part of Old Stage Road, you know, the idea would be to locate the new house in line with the others with the big deep backyard that most of those lots have. So this is one of the criteria in which staff was proposing full points for design for context. A single family home, much like the rest of them, very similarly laid out to the other homes along the road. 11.9.5, conserve open space. Remind everybody that when we look at conserving open space as a review criteria, although in many projects, not this one, the town often requires open space be set aside as part of a residential subdivision, growth management only provides points for open space if it's going to be given to the town or dedicated to another public agency or dedicated via a conservation easement. In this case, the property is 9.78 acres, which is under the 10.5 acre town threshold to require the provision of open space, and also limits the interest of the town or any other parties in owning that open space land or holding an easement over it. So no third-party open space protection proposed, no open space really proposed, other than just sort of the subdivision design, and no points awarded in this category. Minimize visual impact. So the applicants note that the new house, the project, will be visible from Old Stage Road. It will only be visible along the project site frontage. And they are not proposing any additional screening plantings along that frontage, which would be the only way to make the house truly invisible, because those screening trees would also have the effect of limiting the view of Camel's Hump along that public right-of-way. So there's a bigger view shed at play here, another sort of value of the towns that would be in conflict with doing more screening here. So within the minimized visual impact criteria, you get full points for the project being invisible. You get half points or partial points for the project being minimally visible, or no points at all if the project is just completely visible. And staff is proposing the middle road in this scoring criteria, which generates the other 10 points of the 20-point proposed staff score.
Great. Thank you very much.
Thanks.
Deb and Andrea, have you had a chance to review the project overview and the staff scoring?
And I am muted.
Oh, can you unmute them?
All right. Yes, we have both reviewed that report.
So you have Deb and Andrea, you have reviewed the staff report?
Yes.
Yes.
Okay, do you have any questions on the staff report?
I don't at this time, no.
So Deb said no. Andrea, anything?
No questions. I think Matt did a really good job overviewing our application. We had a pretty thorough narrative that we put together as part of our application, supplementary to this questionnaire. But I guess, what I would mostly like to bring to light is that this project was really ineligible to score points in 3 of the 6 categories, that being the build affordable housing, the provide paths and trails, and the conserve open space. I think Matt did a great job describing how the project fits in with the design for context. The existing 9.7 acre lot is actually one of the larger lots along this northern section of Old Stage Road. Most of those properties are between 2 and 5 acres, which is exactly what we're proposing here. A 4.3 acre lot, again, another single family home, and the development will be along Old Stage Road, just like the existing houses. As far as minimized visual impact goes, I think the applicant is open to the idea of additional landscaping, but we did want to hear what the board thought. As I think many of you probably know, this northern section of Old Stage Road has pretty beautiful views out to the east of Camel's Hump and Mount Mansfield. So trying to balance preserving those views and fully shading the house is a bit of a conflict.
Okay. All right.
And then as far as the conserve energy criteria goes, this is a new conserve energy criteria. So we definitely looked at it pretty thoroughly, did a good amount of research. When we started to look at this criteria, we asked, is this feasible for the lot? What's it going to take to have 75% on-site renewable, and what does it take to meet Efficiency Vermont's high performance level? And I think the biggest thing with the McDonnell Gata plan is that they're not planning to develop this lot. They would like to sell off an undeveloped lot and to try to confirm that we can meet this high performance standard and the 75% on-site renewable when we have absolutely no idea what the house is going to look like, who's going to be living there. It just leaves a lot of unknowns to confirm to those. We did also look at, what is the general price. I talked with Suncommon. They gave me an estimate that doing 75% solar on a site like this could be anywhere from $16,000 to $30,000, which is, or $16,000 to $60,000, which is a very wide range. We also talked to one of the neighbors up to the north who has ground-mounted solar systems. They said that it costs about $25,000 to $30,000 to install their system. And I would just note that this particular property is pretty limited for ground-mounted solar, just between, you're not going to put it in between the house and the road. And then in the back, we have the house, the septic system, and then you right up against the class 2 wetland and buffer. So we really would be looking at rooftop solar if that was to be an option. And then as far as the Efficiency Vermont costs, I did reach out to Building Energy, who does a lot of these high performance homes, and they were very kind to give me an estimate, which totaled to about a $33,000 increase to building a 2,000 square foot home that meets these standards. So, you know, all in all, we could be looking at a building increase that's anywhere from $16,000 to $90,000 more than just your standard home, which at this point we feel is a burden to the McDonnells and Gattas. And again, you know, this exemption is made particularly for lots just like theirs. It's under 10 acres and it's a simple 2-lot subdivision.
Okay, thank you. Questions from the audience? Questions from the board? Emily, everybody unmuted?
No, I guess, Scott, the only comment I would make is I appreciate the amount of effort they put into investigating the details of that conserve energy criteria.
Okay. Yeah, it is interesting. It'll be interesting to see how that is utilized by future applicants.
Yes, I had a lot of good conversations with people, so it was a fun little research project for me.
Other questions from the board?
Nope.
No.
Jill?
No.
Let's see, Paul?
Nope.
Okay, all right. Who am I missing?
Just
John?
No questions.
And David, yep, okay. All right, very good.
I do have one quick question, Scott.
Yeah.
Just to clarify, the visual impact narrative says additional plantings are not proposed along the frontage in order to maintain mountain views of Camel Stump and Mansfield. Isn't that the other direction? Isn't the frontage on the west side of the house? I don't know that it matters a whole lot, but I wasn't sure if I was reading this or reading the plan correctly.
That's for views for those that are traveling on Old Stage Road.
Yes, for the public, not for
Or living in the house on the other side of the street.
Oh,
Right.
I'm with you.
Yep.
Thanks.
Is there a Matt or Emily? Is there a street tree requirement here?
We have not typically imposed a street tree requirement in the ag rural district. In a number of places within the landscaping and street tree chapter, you'll find some relief from that to help match a more rural sort of informal pattern.
Okay. Mm-hmm. Okay. Any other questions from the board?
No.
Emily, do we have anybody in the audience who would like to chime in?
I don't believe so. If you're in the audience and you'd like to speak, please press the raise hand button. It looks like nobody is calling in via telephone.
Okay, all right. Deb and Andrea, anything else you'd like to add?
Yes, I would like to make a comment. First of all, thank you, for considering our proposal and for both the allocation and for the exemption. And also, I would like to be genuine with the board and just to clarify that we are not planning to develop this lot ourselves. And at least initially, our intention is to sell our farmland to the farmer next door, to sell to John Adams for use with his apple orchard.
Okay, all right. Well, we hope you're successful with that.
We hope we are too, and I think we will be, Scott.
Good, great. That'd be great. One last time around the board, any questions or comments?
Nope.
Okay.
Nope.
All right. We are going to close DP 20-08. at 8:34. Thank you, Deb and Andrea.
Thank
You're very
you.
welcome. Should we leave the meeting at this point then, Emily?
You can stay on as an attendee or you can leave. You can call me tomorrow and we'll let you know what the results are.
Thank you, and thank you, everyone.
Thank you.
All right, I'm going to promote Kevin up to panelist for the next hearing.
You know, I hit something on my screen and everything just flipped around. I love this system, huh?
Hi, Kevin.
Hi, Emily. Hey, Emily.
Hey, Jesse.
Okay, Kevin and Jesse are up. Okay, we are, it is 8:35. We are going to open DP 20-15, the Mezuzah property. Kevin and Jesse, if you would state your names and your addresses, please.
Sure. Kevin Mezuzah, 1120 Butternut Road. Jesse Lauer, 1120 Butternut Road.
Thank you and welcome. Emily or Matt, you are up.
All right, I'll talk through it and Emily will drive the screen here. So like the project before, this is a 2-lot subdivision intending to request 1 unit of allocation to create 1 additional dwelling unit on a parcel that already has 1 dwelling unit on it. The parent parcel is 5.27 acres. And you can see in the project score table a proposed staff score proposing points in the conserve energy, design for context, and minimize visual impact categories for a total of 30 points, which is the minimum score necessary to achieve allocation. And then we can go over to the questionnaire and I'll go over those criteria one at a time. All right. So what distinguishes this project from the one before is the applicant, in this case, is proposing to have the new unit meet the Efficiency Vermont high performance level of efficiency and is proposing to generate 75% or more of the energy demand for that unit through on-site renewable resources or renewable sources. Therefore, full points are recommended by staff for the energy category. Next up is the affordable housing category. As with the project before, no affordable housing unit is proposed in this project. It's a 2-lot split, generally not feasible for projects of this size to carry an affordable unit. No points are proposed by staff for this category. 11.9.3 is the paths and trails category. This parcel is in a similar situation to the one we just reviewed. So when we go to the town plan map, we do not see town proposed trails that would necessitate a connection across this parcel. No trails or paths are proposed and no points are proposed by staff for this category. Within the design for context criteria, the applicant has provided a narrative describing in general what the development pattern is along Butternut Road and some of the variation of parcel sizes and structures along there. And the proposed lot 2, which would be the development lot on this parcel, would have a approximate 1,200 square foot dwelling with a septic field system and a private well, a lot with about 180 feet plus or minus of road frontage. Overall character of the residential subdivision proposed to be in line with neighboring uses, which is we tend to see this relatively large lot set back from the road, rural subdivision pattern. Staff is proposing points in that category. Conserve open space, similar to the project before. The parent parcel here falls below the threshold for open space, which in this district is 10.5 acres. Even if it was providing open space, growth management only gives points for open space that's proposed through, or that's protected through a third-party easement, donation to a town or other agency. None of that's proposed here, and no points are proposed in this category. And last, we'd go to 11.9.6, visual impact. The applicants are proposing that the new dwelling would have minimal visual impact from Butternut Road. They're proposing to retain existing vegetation to the extent feasible, add supplemental screening as necessary. The applicants are proposing a layout that would require minimal grading and clearing to create the building envelope and driveway. And there is a slope on the project site, and some ability to use that to also minimize visibility of the project. In other words, the new house is not right up on top of the road, nor is it likely to be entirely invisible from the road. Points are proposed there. Here's some pictures the applicants have proposed of the subject parcel. I'll stop there. Just again, going back to that summary table, 10 points in each of those point scoring categories recommended by staff for a total of 30, which would allow the project to receive allocation without needing any exemption from the DRB.
Thank you, Matt. Kevin and Jesse, have you read the staff notes?
Yeah.
Oh, anything, and is there anything you would like to add to them?
To add, no, nothing.
Okay. Questions from the board? Everybody unmuted, Emily?
Dave, let's see, everyone should be unmuted, yes.
Everybody unmuted. Okay, any questions from the board for Kevin and Jesse?
Nope.
I have none.
Okay.
None.
That was a unanimous none?
Correct.
Okay, all right. Anyone from the audience?
No one from the audience.
Okay, nobody stuck their hand up, huh?
No one's pressed the raise hand button, and no one is calling in via telephone.
Okay, anything else you would like to add, Kevin and Jesse?
No, just thank you for the opportunity to go through the exercise. You know, it was interesting. Jesse did a lot of research around conserve energy. The current home that we live in on the proposed parcel has roof-mounted solar, and we're very pleased to say that we're producing 100% of our electrical usage by utilizing that, and we hope to do the same thing with the new dwelling.
Yeah, good for you. That's great.
Yeah, it's kind of exciting. It is. There's certainly some costs associated with it, but we're hoping that as things develop, the price will come down, and more folks will be able to participate in reducing their carbon footprint.
Yeah. Okay. All right. Last time around the board, any other comments or questions from the board?
Nope.
No.
Nope.
Very good. Okay, we are going to close DP 20-15 at 8:42. Gentlemen, thank you for coming.
Thank you.
All right. Bye, guys.
Bye.
Emily, how are we going to go to deliberations? We go back to zoom.us and type in the new meeting ID and the password?
Yep. So you'll go to a separate meeting. You should have those instructions in your packet. I'm going to leave the webinar running. I'm going to join the deliberations on my phone. If you're attending in the audience, the webinar will be silent for a little bit. And then we'll rejoin the webinar to do motions and vote.
Great.
Mm-hmm.
Okay, so
do we leave this meeting or we leave this one open?
I'll leave this one open, so you guys leave this webinar.
Okay.
Yep.
So we leave the meeting.
Yep. Leave this one and then rejoin the other link that is in your packet.
Leave the meeting,
So
okay.
is there another link that you sent via email? Because I don't know if I have.
You might have gotten an automated email. What I can do is send out that link via email right now.
Jill, it's in your, oh, that'd be great too, Emily, if you can do that. Jill, it is in your packet under, on that first white page, Zoom instructions.
Yeah, everything's out of order here, so I can find it. It just might take a minute.
Mm-hmm.
I also don't have that in front of me.
Bonnie, and Matt, I'll CC you on this email.
Great.
Yeah, you're gonna send it to everyone, Emily?
Yes.
Okay.
I know I did see a Zoom instructions, but
It should have been the first page in your packet.
I think it was. But
Management.
where it went to is a mystery to me. Sorry.
All right, so
All good.
I'm gonna leave the meeting and see you on the other side.
See you on the other side. Okay, hey everybody.
Hello.
I am adding Pete in.
Not quite everybody yet, huh?
They are joining in. Kevin Mezuzah's still in as an attendee, as well as Channel 17.
Okay.
I guess I should theoretically rejoin the public iPad that's sitting next to me, but there's nobody here.
All right, and I see Dave and Jill.
I don't see Pete up yet.
Yeah,
He's already in.
I can hear you guys.
Oh, I'm asking you to start video.
Oh, there's Jill. There's Pete.
There you go.
Great.
Bless you.
And Emily, we have everybody?
We have everybody.
Okay, so everybody, we're going to go through the motion section. We're going to go through the motion section. There are two motions that are that have been written. I'm going to ask for someone to make a motion. I'm going to let you guys decide. Basically, we're reading it. But would you state your name prior to reading it, and then you will have to state your name again when you read it. I think that will get us through it. Anybody have any questions?
Do we need to fill out table 4 before voting? It looks like the motion references table 4.
Yeah, it does. And I was going to suggest that we utilize the staff's proposed allocation schedule for that.
So do we just strike the words as shown in table 4 and say as shown in staff allocation?
Staff's proposed allocation schedule.
Yeah.
Everybody agree with that?
Yes.
Okay. Everybody ready? Okay. So the Town of Williston's Development Review Board is out of deliberation on March 24th, 2020 at 9:13. Two items that we'll have motions made on them. First up is WDB. No, that's not it. First up is WDB 11.8, other sewer services, service area allocation. Would a board member make a motion, please? Don't all jump in at once.
Okay, I will make a motion. This is Jill Spinelli. So as authorized by Chapter 11 of the Williston Development Review Board, I, Jill Spinelli, move that the Development Review Board, having reviewed all the submitted growth management questionnaires and accompanying materials, including the recommendations of the town staff, and having heard and duly considered the testimony present at the public hearing of March 24th, 2020, make the following allocation of dwelling units within the growth target established by Chapter 5 of the Williston Comprehensive Plan within the town's other sewer service areas as shown in the proposed growth, proposed score by the town of Williston as shown on the project score sheet. Let's see, established by the Development Review Board on March 24th, 2020.
Second.
So who seconded that?
Christensen.
Okay, Paul Christensen seconded. Any further discussion? Everyone agrees that we are utilizing the growth allocation schedule as developed by the staff of the town of Williston zoning department.
Yep.
Okay, and this does relate to DP 17-01 Northridge. All in favor?
Aye.
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 Recuse.
Okay, somebody give me a count on how many we got.
John said aye.
So what do I got? I got Pete recused,
Dave recused.
Dave recused,
Everybody else is an aye.
Don, Jill, Paul, and Scott.
so 4.
And, yeah.
Okay, thank you. 4. So we have 4 ayes, 2 recusals, no nays, motion carries. Staff, you follow all that?
Mm-hmm.
Okay. All right. Next up is WDB 11.9 outside sewer service area allocation for DP 20-08 McDonnell data and DP 20-15 Mezuzah. DP 20-08 McDonnell data. It does score below the 30-point minimum and is eligible for an exemption. Do I have a motion, please? Pete.
As authorized by Chapter 11 of the Williston Development Bylaw, I, Peter Kelly, move that the Williston Development Review Board, having reviewed all of the submitted growth management questionnaires and accompanying materials, including the recommendations of the town staff, and having heard and duly considered the testimony presented at the public hearing of March 24th, 2020, make the following allocation of dwelling units within the growth target established by Chapter 5 of the Williston Comprehensive Plan outside of the town's sewer service area as proposed by staff, established by the Development Review Board on March 24th, 2020.
Would someone like to make a second?
I'll second that.
That sounds
John.
like John Hemmelgarn to me.
Yes, you were correct.
Okay, very good. John seconds it. Any further discussion?
We need to add to the motion that we are utilizing our exemption.
Yep. I did mention that in the beginning, and I do agree. We are utilizing one of our 4 exemptions for DP 20-08 McDonnell data. Everybody in agreement?
Yes.
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 Okay. All in favor?
Aye.
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 I count 6 ayes, no nays, motion carries. That takes care of growth management, everybody. Any questions before? Any questions on that? No? No. I have a motion to approve the minutes of March 10, 2020.
I'll make a motion to approve the minutes of March 10, 2020, as proposed, as written.
As written. Do I have a second?
I'll second that. This is Dave.
Dave seconds it. No further discussion. Any further discussion? All in favor?
Aye.
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 6 ayes, no nays, motion carries.
I do have one chat. Okay, Kevin just said thank you.
Yep, Kevin said thank you. Yeah, pop
All
up. And do I have a motion to adjourn the meeting at 9:19?
So moved.
Everybody, thank you very much. This was great. Stay safe out there.
Everybody have a good, safe commute home. Watch out for the kitchen island.
You've been waiting all night to say that, haven't you?
Took a long time to come up with that. Have a great night. Thanks, everybody. This was
Good night,
terrific.
everybody.
Good night.
Night. Have a good one.